Good morning, class, once again. I remain Dr. Bello Mohammed Magaji, an Associate Professor of Law, American University here in Yola. In continuation with our lecture series on the law of contracts, particularly the formation of contracts or the elements of the formation, we shall be looking at the final element, that is capacity to contract as an element. Now, the law of contract deems that, as we've seen the definition, it must be a legally enforceable contract. The law feels that some category of persons are granted some form of protection so that they will not be cheated, as it were, when they are entering into an agreement in the law of contract. The capacity of such people include illiterates, we have infants or minors, we have persons of unsound mind, and drunk persons. These are categories of persons that the law protects when they are entering into a contract. Who is an illiterate? Let us start with the first category, that is an illiterate person. An illiterate person is granted some protection by the law in entering into a contract. Now, for an illiterate person, the case of PZ and Company Limited versus Guzau and Ankantoma are the judicial authority as to who an illiterate person is. Now, capacity of an illiterate in an oral contract. Now, a illiterate person who is entering into a contract, whatever the contract is, must understand the language of the contract. An illiterate here is defined, is looked upon as a person who does not understand the language of a contract. If, for instance, a Hausa person who is purely Hausa and doesn't understand Fulani or Fulfulde, and he is, as far as the law is concerned, an illiterate in Fulfulde. So if a contract is to be entered in Fulfulde, there must be compliance with what we call the Illiterate Protection Act. Now, the same applies to contracts in writing. Now, under such a protection, each section of the country has a law that protects illiterate when they come to enter into a contract. For instance, in Lagos State, Section 2 of the Illiterate Protection Law of Lagos, or in the whole of Western Nigeria, we have Section 8 of the Land Instrument Registration Law of Western Nigeria, which gives protection to an illiterate person, that when you are entering into a written contract, certain provisions of the law must be complied with before the contract could be what? Enforced. Now, the next issue we move to is, how do we prove somebody is an illiterate? The law presupposes, push the burden of proving that to an illiterate to the person who claims he is an illiterate. But provided that a person is an illiterate, prima facie, you must comply with the provision of the law. Now, why do we have this law? As I have earlier said in the introductory part of the lecture, the purpose of it is to protect the illiterates, is to protect them so that they are not in any way disadvantaged when entering into a contract. Now, in the case of Ugunde versus Abdul Salam, reported in 2007, and the case of Abubakar versus the state, reported in 2015, goes to support the purpose or state the purpose of the illiterate protection. Now, what is the effect of non-compliance to such law? The case of Odopolo versus Odopolo goes to state the fact that if you do not comply with the Illiterate Protection Act, then that contract is voidable. Now we go to the second category, that is the infant or minor. Now, who is an infant? The common law and the Infant Relief Act 1874 and Infant's Law of 1957 defines who an infant is. We have a different definition of who an infant is under this law. Now, the effect of a contract by an infant is that under the common law, the contract is void at his own instance. We have also intervention of the Infant Relief Act 1874, which makes any contract entered into by an infant void, especially the following contracts. Contracts of a loan. If an infant enters into a loan contract, that contract is void ab initio. Now, contracts for non-necessaries, non-necessary goods. This is a contract that is void ab initio if an infant enters into such a contract. Now, there's what we call accounts stated. Once an infant enters into such similar contracts, the contracts are what? Void ab initio. Now, the contract entered into by an infant, we said if it is non-necessaries, it is void. But if they are necessaries, having regard to the capacity, to the status of the infant, the law will what? Will enforce such a contract. If an infant also enters into a contract of apprenticeship or beneficial contract of service, the contract will be what? Enforced against the infant. Now, what happens if there is misrepresentation of age? If an infant who is a person who is above the infant range category claims that he is an infant, definitely the court will look into it as a case of a fraud, and then accordingly the court will enforce that contract against the person. And then if it is a loan, it will be repayable by such a person who misrepresents his age to claim that he is an infant. Now, the last category, another category are drunk persons. What is the position of a drunk person under the law of contract? This situation is similar to a person of unsound mind, because I will jokingly say that a drunk person and an unsound person of unsound mind, who we call mental, or we call a mad person, they are cousins as far as I am concerned. So, but the law protects them. If you enter into a contract with a drunk person, when he is drunk, the law will not enforce that contract, because it will be deemed that you have taken advantage of his drunk state to enter into the contract with him. But of course, there must be proof of his intoxication. The other party must also be aware of the intoxication. You must be aware that he is drunk while you are entering into the contract with him. If you are not aware, that is a different ball game. And then, of course, there must be proof that such a person is drunk. Now, to his senior cousin, person of unsound mind, who we call mad people or insane person, only a contract of necessaries will be enforced on him, which will be binding. But generally, the law protects such a person, that he will not be forced into a contract which he has entered when he is mad. Now, let us look at a situation when he is not mad, because we have what we call lucid period, when a mad person possesses his mental capacity. If he enters into a contract under such a circumstance, the law will enforce that contract. As I have said, these are all protection offered by the law to persons of unsound mind, persons of drunk persons, illiterate, and minors, just to protect them while they are entering into a contract. If, as I have mentioned here, there are certain cases and certain provisions of the law which I will invite the class to go and check up these provisions, which for them to read up for further elaboration, as this lecture will not allow us to elaborate further on that. Thank you very much.